Hello and welcome to our panel on the looking forward and backward at the Refugee Convention. This is, of course, the 70th anniversary of the Refugee Convention. So we wanted to look at how refugee law has developed over the last 70 years, but also what's the future, what we're looking forward to. My name is Alice Farmer, and I am one of the co-chairs of ASIL's International Refugee Law Interest Group. My other co-chair, Ian Kissel, is with us as well today. We are very fortunate and glad to be welcoming some excellent panelists to today's discussion. We'll be starting with Mr. Volker Turk, who's the United Nations Assistant Secretary General for Strategic Coordination. Prior to joining the Secretary General's office, Mr. Turk served as the Assistant High Commissioner for Protection for the UN High Commissioner for Refugees. Before that, he was director of the Division of International Protection, known as DIP, within UNHCR. So he has a vast amount of experience with international refugee law, and we're very glad to welcome him. Our second speaker will be virtually from Professor Guy Goodwin-Gill. Guy is the Professor of Law at the University of New South Wales and an Emeritus Fellow of All Souls College, Oxford. His scholarship on global refugee law is known worldwide, and many of you may know his seminal book on the topic. Guy, unfortunately, won't be able to join us in person, but he has sent over a copy of his remarks, and so Ian has graciously agreed to summarize some of those remarks for us. And we'll also post a video link to Guy explaining his what he would have liked to present at the panel if he could have been here in person. Our third speaker then will be Judge Ashley Tabador. Judge Tabador was recently appointed as the Chief Counsel for United States Citizenship and Immigration Services within the Department of Homeland Security. Prior to that, served as an immigration judge with the Executive Office for Immigration Review at the U.S. Department of Justice. She has decades of experience on the immigration bench in the US and served as the president of the National Association of Immigration Judges here in the US for some time. Final speaker will be J.R. Ramji Nogales. Professor Ramji Nogales is a specialist in immigration law and international law at the Temple University Beasley School of Law. And we are very grateful to her for joining the panel and discussing some of her recent scholarship on US law and beyond. So I'm very grateful to have all four of these wonderful panelists, even in a slightly unusual format for all of us gathering, but these are the times of adapting to change. And I'd like to turn over to Volker to start with some initial remarks, and then we will hear from each panelist and move to discussion.
Well, thank you very much, Alice, and great to be part of this panel on the occasion of looking ahead and looking backwards on 70 years of the 1951 Refugee Convention. And I think it's always interesting when we have anniversaries to actually see what these anniversaries tell us, because it's a bit stepping back in time and going back to when, frankly, the United Nations was founded in 1945, because let's not forget, we had the 75th anniversary of the United Nations last year. And a declaration was adopted by all member states last year, which had as one of its commitments to abide by international law. And it's interesting when it comes to abiding by international law, how this actually translates in the refugee context. And if you go back to end of the Second World War, it was clear that the world was faced with enormous refugee and displacement movements all around the world. I mean, we sometimes forget that in Europe itself, you had some 60 million people uprooted as a result of what had happened, not least the persecution by the Nazi regime and the turmoil of the events surrounding the Second World War. Very early on, the UN, the United Nations, recognized in one of its earliest resolutions that the refugee issue is international in scope and character, and that was in 46 already. And it was really amazing, and it's good to go back to that time, that the 1951 convention was then created as an instrument that did a number of things. First of all, it put the human rights dimension forward of refugees. It almost goes back to the time of Georges Sell as the French law philosopher who wanted the world to move away from a state-centric national sovereignty type view of international law in the 30s. He actually wanted to make sure that the individual has access to law and to rights. And frankly, the refugee character was such that it actually revolutionized thinking in international law because it made sure that refugees have access to the international plane. And so the 1951 Convention is a human rights instrument first and foremost, but it is also an instrument of international cooperation. It is about the conduct of states and how states deal with each other when it comes to the management of refugee issues. And let's not forget, that's an important element as well. Thirdly, it embodies a limit to national sovereignty, and that's huge. And Guy, I think, who is the real expert on the principle of non-refoulement, will talk about this. It actually says to sovereign states that you cannot return people to persecution, to situations of violence and war. And that's huge because it actually makes clear that these are elementary considerations of humanity that prevail over any concept of national sovereignty. And I think that's important to understand as well. Fourth, the convention has its own checks and balances when it comes to national security considerations. I think that's important because sometimes there is a myth out there that the convention is blind to national security issues. It isn't. It even includes in the definition exclusion clauses for people who have committed particularly serious crimes or crimes against humanity. Fifth, it has created an institutional link with one UN organization, the United Nations High Commissioner for Refugees, and the supervisory role that UNHCR has in relation to the application of the provisions of the convention. And that really has been a dynamic feature of progressive development of law, because the 51 Convention is not stuck in time. It has allowed to embrace new forms of persecution, to recognize them, especially from a gender and age-specific perspective, gender-related persecution, child-specific forms of persecution, but also through an evolution of thinking around membership of a particular social group, for example. So in many ways, the convention is the core, but it has triggered and activated an international refugee protection regime that has informed practice and the protection of people who flee persecution for the last couple of decades. And that's a huge testament to the aliveness of this convention, to contemporary forms of persecution. But it also has some gaps, and we can talk about the gaps, I think, in the course of the discussion. Thanks very much, Alice.
Thank you, Volker. That gets us off to an excellent start. Ian, I wonder if you could step in and represent some of the thoughts that Guy might have brought to us.
Happy to try to do so. Certainly a challenge and an honor to try to summarize such a substantial contribution from Professor Goodwin-Gill. In the ease of technical simplicity and time, I'll share some, but we do hope to make available a link to a YouTube recording of the full set of Guy's remarks. Guy emphasizes a few things. First, in this anniversary year, it's important to note that in addition to 70 years of the convention, it's 70 years since UNHCR was set up and 100 years since the League of Nations appointed Fridtjof Nansen as the first High Commissioner for Refugees. So much to celebrate, but also some important aspects to inform reflection. Guy has emphasized a few things. One, really taking off from Volker's reflection on the cornerstone institution of the norm of non-refoulement, that an observation that of course in the convention itself is and was a source, but that the principle has really, as Guy described, slipped the bounds of the 51 Convention, both because the norm has analogs in the 1921 principle of no compulsory return in the absence of sufficient guarantees of security. So it's a longer institution than the convention itself, but also because it finds support both in independent custom and customary international law, as well as complementary legal provisions such as that in human rights law. Second, an emphasis that the needs of refugees were a little different at the time of the adoption of the convention than those of refugees today. Protection, refuge assistance, self-sufficiency, the opportunity to work and not be a burden. And so the institutions, of course, have changed, but the challenges in many ways are the same. And so effective management and humane solutions demand a similarly coordinated response. Again, I think echoing some of the principles that Volker made. And so this creates an opening for a proposal in Guy's remarks. And certainly, again, I'm glossing over a much more detailed exposition of the first points, but a recommendation that in this anniversary year, what's needed is not a new convention to tackle these problems and to ensure consistent protection of refugees, but rather a substantially revised institutional base for UN activities concerning displacement. And in particular, Guy's recommendation is revision of UNHCR's statute. To do away with historical anomalies and redundancies and to reflect changes that have already been made, but to formalize them in relation to new realities. And I just want to articulate the 6 specific recommendations that Guy shared in his remarks. One, that revision should recognize that the term refugee with a well-founded fear should accommodate contemporary practice, including gender and sexual orientation. Second, consistent with the non-refoulement requirement of CAT 84 and jurisprudence interpreting the ICCPR and in regional courts and tribunals, the term refugee should also come to include those who have substantial reasons to believe they will be at risk of torture. Third, again, taking into account regional developments, the term refugee should include those who have fled or who cannot return to their country of origin by reason of internal or international armed conflict or events seriously disturbing public order. Fourth, stateless persons should be included as defined in the relevant treaties. Fifth, IDPs, internally displaced persons, should be included as they are now defined in the widely accepted guiding principles. And then sixth, and perhaps as Guy notes, most controversial, one particular category of migrants should be included, those who have been moved or who have moved voluntarily or involuntarily from one state to another, irrespective of their status or whether or not they have been smuggled or trafficked. And in making that recommendation, Guy emphasizes the loss of connection and the ability to call on the diplomatic protection of one's state of nationality. So as Guy notes, in conclusion, a revised statute won't impose obligations on states, but by providing UNHCR with a sound juridical basis for a broader set of operations for protection and solutions, it will help fill an important gap and complement states as they seek to implement the 51 Convention going forward. Thank you.
Thanks very much, Ian, and thanks for stepping in on behalf of Professor Goodwin-Gill. And I will remind participants that we are going to post a video that Professor Goodwin-Gill sent over for us, so we'll be able to look at those points in a little more detail. I do very much want to get back to a discussion of some of the points raised by Volker and Guy when we get to the discussion portion of our panel here today. But first, I'd like to turn over to Judge Tabador for some reflections perhaps on how the convention is being implemented in the US over time, and particularly looking at how we have been able to operationalize a way of determining who is a refugee and who isn't.
Thank you, Alice. And Ian, you did a great job of summarizing the professor's remarks. And it's great to join this distinguished panelist. Thank you for having me. I think when we talk, I spoke that I would probably be best suited in explaining some of the practical sort of operational implementation of the refugee asylum laws within the United States. And I hope to be able to highlight both the challenges and I think some of the successes. But to sort of put it from the bird's eye view, essentially, in the United States, the United States Constitution doesn't speak as to immigration or any sort of obligations of refugee or asylum seekers. And while we are obviously signatories to the convention and subsequently to the Treaty for the Convention Against Torture, in large part in the United States, the obligations under those treaty signatories is done through domestic immigration sort of statutory law. So when it comes to asylum protections or refugee protections, there's a heavy emphasis on the implementing statutory provisions, which is the Immigration and Nationality Act or the Refugee Act of 1980, which implemented first our obligations under the United States as party to the 1967 protocol, and then we have implemented the Convention Against Torture through regulatory implementation subsequent to the authority under the Foreign Affairs Reform and Reconstruction Act. For purposes of sort of practical implementation, the vast majority of what happens is rested within the executive branch of the United States government. And I think it would be helpful to explain some of those players. Probably the biggest player right now is the Department of Homeland Security. And particularly three components within the Department of Homeland Security, CBP, ICE, and USCIS. That would be the ICE being Immigration Customs Enforcement, sort of the domestic enforcement. USCIS, the agency where I'm now working with, is United States Citizenship and Immigration Services, is the benefits arm, which accepts the large portion of the incoming applications for asylum. So individuals who are in the United States can apply affirmatively for asylum, and those applications are adjudicated within USCIS. And Customs and Border Protection interacts with asylum seekers at the border at the time of apprehension. That's where individuals who do come to the United States and express fear, the first sort of practical interaction with the United States government is through that CBP officer. The immigration court, where I spent a good 15 years, is frankly where most of the cases end up, which is that individuals who, let's say, come at the border, express a fear, are subjected to what's called a credible fear review. It's sort of a threshold minimal level of assessment of whether someone has a viable claim under our asylum laws or Convention Against Torture. If they do pass that, they are then put currently in the immigration court proceedings. The immigration court is unusual in that it is a court in a law enforcement agency. So it is headed by the Attorney General, who is within the executive branch. And post 9/11, immigration has obviously garnered a whole lot of attention. Prior to that, we were, the court and immigration was pretty much, we would say sort of the stepchild of the Department of Justice. And of course, prior to 9/11, there was no Department of Homeland Security. So I think it is important to note that within the United States, particularly post 9/11, all the discussions about refugee protections and asylum are colored by the experience of 9/11 and the creation of the Department of Homeland Security and emphasis on recognition of the issues that were born out of 9/11. At this point, I think the challenges that we are sort of facing is obviously the sheer volume of individuals who are appearing and seeking protections, particularly at the southwest border or the southern border of the United States from the Central American countries. And I guess I should just step back because I think I jumped over it. People may not realize that, just putting numbers in perspective, the immigration court has about 70 courts across the country. There are approximately 525 judges now. It's almost doubled in the last 10 years in response to these numbers, but there's a backlog of 1.3 million cases. And the nature of the claims have changed. And I would say in the last 10 or 15 years, under asylum law, as we know, there are 5 protected grounds on which people can request a protection from, race, nationality, political opinion, religion, but sort of the catch-all, the particular social group. And I think this has been part of the conversation that's been highlighted, which is the changing nature or the evolution of the individuals seeking protection. And right now, the vast majority of individuals seeking protection is under that catch-all particular social group. And that has been an extremely difficult sort of provision to administer as it's been subjected to varying interpretations. And because of its sort of position within the executive branch, it has been subjected to sort of movement, I would say pendulum swings. And then finally, to speak as to sort of the evolution of it, I think in the United States, there certainly has been an evolution and an attempted recognition that there is a change in terms of there has got to be a growth with that. And I think over time, sort of the LGBT community has gained some ability to be recognized as a basis for protection, particularly in certain circuits in the United States. Gender has been more of a controversial piece on that, and as we know, sort of the claims of domestic violence have been the subject of great debate within the United States. So I think I'll leave it at that because I think I've sort of highlighted a number of issues that we can certainly talk about at length.
Thank you so much, Judge Tabador. That really does highlight perhaps some of the central holes that Volker pointed to. Like one of the key holes often discussed is the definition of PSG and exactly what we mean, and how there can be some inconsistent jurisprudence on that, not just within US circuit courts, but across the world. Professor Ramji Nogales, I wonder if we could turn to you, perhaps for some reflections on the recent years in the United States and where you see things going in the next for US policy in the near future.
Absolutely. Thank you so much. So first of all, a big thank you to the organizers and our hosts and to my co-panelists. As Alice suggested, I'm going to give just a quick big picture overview of changes under the Trump administration and then the challenges currently facing the Biden administration. So I will walk through it rather high speed. What was really a 4-year effort by the Trump administration to destroy the refugee resettlement program and to dismantle the asylum system. I'll talk about changes they made to the substantive law, to the law of asylum in the US. I'll talk about procedural changes they made, which maybe are less visible, but really dismantling the asylum process and the immigration adjudication process more generally. Then I'll talk about their efforts to exclude asylum seekers at the border. And then finally, the most successful effort, which was the COVID ban. So as most of you probably remember, in Trump's first week in office on January 27th, 2017, he implemented the Muslim ban, which prohibited the entry of nationals from certain Muslim majority nations, including and in particular focused on Syria, which is where we saw very large numbers of refugees fleeing. After 3 iterations of this ban, the administration had to revise it 3 times in response to court challenges. It was finally approved by the Supreme Court in June of 2018 and just now dismantled when President Biden came into office. Really, right around the time that happened, he moved into his administration moved into trying to shut down the asylum office, the asylum program. And I should know, for people who are unfamiliar, the refugee program, the refugee resettlement process in the United States is for people who are determined to be refugees overseas, who cross the border from their state to a neighboring state and are determined usually with the assistance of the UN High Commissioner for Refugees to be refugees, and then they're brought over to the US. That program was dramatically, the last year of the Obama administration, there were 110,000 folks being brought over. By the end of the Trump administration, it was down to 15,000 in the face of the highest numbers of forced migration on record. Asylum seekers are those who come to the US and seek protection either at the border or within the interior of the US, and they go through the US asylum process. So the administration made changes to the substantive law that Judge Tabador mentioned, particularly focused on women escaping domestic violence, trying to prevent those claims from being viable, but really more generally, any claims based on persecution by non-state actors, by gangs, by cartels, by domestic partners, by anyone who's not the government. The Trump administration made many, many efforts to shut those claims down, despite the international law to the contrary. These were clearly non-state actor persecution was clearly recognized in the convention, and as has continuously been recognized by others. We also saw many procedural changes, so lots of bureaucratic hurdles being implemented, requirements for new forms, newer increased application fees, employment restrictions, and importantly, we really saw a real effort to gut the immigration courts, which Judge Tabador, as the head of the National Association for Immigration Judges, worked to fight, but it was really distressing for those of us who care about the system to see what they did to the immigration courts. Then probably what most of you are most familiar with, the efforts to exclude asylum seekers at the border. We can break these down into deterrence policies, eligibility policies, and actual border closure policies. So again, probably most of you are familiar with the cruelest of the deterrence policies, which was the family separation policy that began, the zero tolerance policy that began at the border in April 2018, where parents were prosecuted for illegal entry so they could be put into jail and their children could be ripped away from them. That ran really in earnest through June of 2018, but we still have many separated families and many of us are working to reunite those families. We also saw restrictions on eligibility. Interestingly, and I'm happy to talk about this in Q&A, many of these restrictions on eligibility were justified in the language of international refugee law, focusing on specific provisions of international refugee law and claiming compliance with international refugee law. So I'm not sure what this means. I'm still working through, and I would love to hear actually from my co-panelists about what they think about this. So in November of 2018, we see the first asylum ban for folks who have entered without inspection. That violates not only the language of the Refugee Convention, but the plain language of the statute, and was shut down quite quickly by the federal courts. In July of 2019, we see the third country transit ban. So anyone who's transited through a third country on the way to the United States, including Mexico, and not claimed asylum is not eligible for asylum. Then we saw the border closure and pushbacks. We see what's known as the migrant protection protocols in December 2018, where people seeking asylum are pushed back into Mexico while they wait for their asylum claim to be heard. The Biden administration is in the middle of dismantling that policy. We see the asylum cooperative agreements with El Salvador, Guatemala, and Honduras in November 2019, where asylum seekers are sent to those countries with non-existent asylum systems to seek protection. Guatemala is the only one that was implemented. All of these policies were ended by Biden. The one remaining policy that is in place is the COVID closure that started in March 2020 under an order from the Center for Disease Control and the Department of Homeland Security. I'm happy to talk more about this in Q&A, but it was a very dubious use of the law and violates these later statutes that Judge Tabador spoke about, the Refugee Act and FARA. The Biden administration is no longer applying this ban to unaccompanied minors, but it has expelled over 70,000 people in February 2021, including families who may be sent to Mexico. So there's now this and I know I'm over time, so I'll wrap up very quickly. There's a very complex humanitarian situation at the border that the Biden administration is managing. There have been many positive changes. As I said earlier, we're all trying to row in the same direction, but this is a very, very complex humanitarian situation where we have hundreds of kids in CBP tents at the border, and the Biden administration is trying to match these unaccompanied minors with sponsors who can take them as quickly as possible. But in the meantime, we need systems, and after all the destruction of the Trump administration, it's going to take a while for this administration to build back the systems in place, but at least they're trying in earnest and working with UNHCR to make the system function again. Thank you.
Thank you very much, Professor Ramji Nogales. You're raising a lot of interesting questions there about how to operationalize refugee protection, even within an administration that is ostensibly in favor of doing so. I'm conscious a little bit that our timing is a little askew just because we started recording a little with a delay. So I do want to turn our first question over to Mr. Turk, who might have to leave us. Volker, I wonder if you might reflect a little on some of the things that have come out of the remarks of your other panelists. First, looking at Professor Goodwin-Gill's proposal for a UNHCR statute reform, and whether you see that as part of how to make refugee law more robust in the future, whether that corresponds with your own work on the global compacts, and perhaps whether that does affect states' capacity to claim compliance even when they're not being compliant, which is something we very much saw during the Trump administration. So I'm perhaps pulling together too many elements here, but we very much welcome your reflections.
Look, I mean, it's obviously very interesting what Guy has said about the evolution of the statute. And in fact, what is interesting is that the statute itself, when it was drafted in 1950, had already provisions in it that allow for a dynamic evolution of the competence of the office. So, I mean, a number of things on stateless people, for example, on internally displaced, on even the thinking on the convention, in a way has been influenced by subsequent General Assembly resolutions. And I think it's always important to see, as I mentioned earlier, to see refugee law as a dynamic body of law, practice, and standards. I mean, the judiciary has been enormously helpful in developing it further, for example. The fact that UNHCR exercises its supervisory responsibility, including in relation to courts. That's amazing, you know, that the UN organization is actually that courts want the UN coming in with its expertise and its authority on international law to advise them on some tricky issues of international law. And you mentioned the membership of a particular social group, persecution on the basis of sexual orientation and gender identity, gender and so child-specific forms of persecution. I think that's fantastic. We need to absolutely preserve that ability. So whenever you throw something out, we need to see what it is that we are going to get in return. So I think that's always a big concern that one has. There has been an amazing process, and that really goes a little bit also to the discussion that I heard both from Ashley and from Chaya. We, over the last couple of years, managed to get through a global compact on refugees to which almost all member states, with the exception of 2, have signed on. And that global compact is really addressing one of the big gaps that the international refugee protection regime has had until now, which is to define better burden and responsibility sharing, especially this concept of responsibility sharing. And it actually gives you a menu of the type of action that is required when countries are faced either with a protracted refugee situation or with large-scale influxes of refugees and asylum seekers. So, I mean, if one were to look at the Global Compact in the context of the situation that you are facing today on the southern border, it actually almost gives you a menu of option of the type of things that could be done. And I think that's really fantastic because it also goes beyond just how the US is managing it. It is also the interaction, obviously, with the countries of the Northern Triangle of Central America. It's the interaction with Mexico, building up asylum structures there, making sure that we find ways and means that people have access to asylum, including, as Chaya mentioned, through resettlement, because that often helps in making sure that people do not take on dangerous journeys that are horrible, as we hear from people who come to the southern border, but actually try to find ways and means to better protect them earlier on and to find resettlement solutions for the ones who are found to be in need of protection and who need to be sent to a third country that provides them safety. So the Global Compact is a remarkable achievement of international standard setting, if you like, without it becoming an international treaty. So it's been subscribed to by most member states. In fact, the vast majority of them, including by the US. They didn't actually sort of sign on to it because there was no signing on, but the US has maintained that it very much supports its main tenets, and I think that's very, very important because I think it does give us a blueprint of action when countries are faced with particular challenges, including what you're facing now here in the US. Over to you, Alice. Thank you.
Thank you, Volker. I wonder if any of you have reflections on how the pandemic changes access to territory. Jaya, you had mentioned this in the context of Title 42 in the United States, and that is the one Trump administration policy at the border that has been kept in effect. And that is a policy that excludes asylum seekers from accessing the US to make their claims, and is now being applied to everyone except unaccompanied children. But I do think that that begs a bigger question, which is, in light of the pandemic, where are we going to result in terms of access to territory? Like how, when we have an administration as perhaps favorably disposed towards asylum seekers, as the Biden administration is, but they're still keeping this kind of policy in place, where do we go next? And what effect will that have? What effect broadly will the pandemic have on access to territory down the line?
Yeah, it's a great and important question. You know, and I do think we will see, to some extent, increasing inequality in travel, which implicates the concerns that Volker raised about safe transit, right? So about the dangerous journeys that people need to take. And so if we see, you know, these vaccination passports and other things, that will just mean that you're really eliminating more and more people from the safe transit routes that they should have access to. At the same time, on a more positive note, I really think it depends so much on the administration. And maybe, as we're seeing in the US, you know, we see hopefully some political tides turning to some extent because of simply the horrors of what happens when you exclude people at the border in the dramatic way that the Trump administration has when you separate families. So I'm hopeful that we'll see some changes. You know, what I really think is happening with the Biden administration, it's really my hope, is that they just need time. They need time to set up infrastructure. They need time to work with UNHCR. The plans that the Biden administration has laid out are incredibly promising, right? So, and really kind of map on to a lot of what Volker was talking about. So one thing I want to emphasize is they're working on creating more opportunities for legal migration more generally from the region. And this is really important in diminishing the pressure on the asylum program. So many are folks needing protection. Some folks are coming for work for jobs that are here that they're going to get. So, right. So enabling people to migrate lawfully for a variety of different reasons, and also working at the same time in the region, right? President Biden obviously has deep familiarity with the Northern Triangle. He visited 14 times as vice president, right? He really has implemented some promising programs there. So working within the region to enable people to stay where they are, for example, to enable smallholding farmers dealing with climate change problems, to provide them measures of adaptation and mitigation to enable their resilience. The administration is working on setting up entry points for unaccompanied minors in country, right? The Central American Minors Program was not so successful under the Obama administration, but I really hope, as Volker does, that this is if this program can be executed thoughtfully and with enough resources, this is a way to eliminate those unsafe journeys, and providing also refugee admissions and resettlement spots from within the region. So simply the idea, I think, is to take pressure off the border, and I think my hope is that once the Biden administration is able to process people at the border, they will end the COVID ban at the border. And the promise of the future is that if we have forward-looking administrations like this, we can actually move into a world where we see a regional processing programs that signify perhaps a turn away from these really harsh border closure policies, because the human cost is just so tremendous in these policies.
I think Professor Ramji Nogales is correct in many ways. I thought I would just add one more to the conversation, which is obviously the president, through the executive orders, has really laid out some wonderful guiding principles. And I think it is important to take a look at those. And the foundation of that is about just the humanity, sort of that we need to recognize that we do have that obligations to other individuals to treat them through sort of the humanity lens. But one thing I have seen, which has been interesting in terms of the impact of the pandemic on government, sort of as a government employee, is how much it has forced us to sort of jump into the 21st century in terms of technology. So I see that as sort of a wonderful thing. You know, right now our work, you know, my team, we have about 330 attorneys at the Office of Chief Counsel, has been on telework mode 100% since last June, and has been as effective, if not more effective. We've talked about how it's brought in a lot of not just morale boosting, but flexibilities. We're of course now working around the clock as people are, have that flexibility. And what we're also looking at ways to connect through that technology, sort of to try to bridge that gap of the physical distance. And so I see that as a potentially really positive development. A lot of it, as the professor noted, so much has been dismantled, so much has been sort of destroyed, so that it's so much easier to destroy than it is to build, and that takes time, and it takes money. So, so appropriations and and sort of being able to garner that kind of support is also part of the solution.
Thank you, Judge Tabador. Volker, I know that we have to let you go, so we thank you so much for your participation, and we will circulate some follow-up links. And for those in the audience, we will hope to include some links to the Global Compact and some other things that were referenced today. So,
great.
Thank you, Volker.
Thank you very much.
Good to meet you, Volker.
Thank you.
Great to meet you.
Bye, Volker.
Thank you. Bye-bye.
And if the other two panelists are so gracious to give a little bit more time, I will ask you another specific question, I think. I'm very interested in your thoughts on where particular social groups might go from here. And perhaps to add a forward-looking lens to that, if you had a magic wand and could add one particular thing to the refugee definition, what would you do? How would you shake things up, and where do you see a particular social group going?
I would just sort of add, in terms of particular social group, that the president, through the executive order, actually highlighted particular social group as an area that is critical as part of the sort of the global approach or this multilateral approach to our obligations for asylum refugees. And I just to kind of put the practical light on it, is that the executive order has sort of instructed the federal government, the executive branch, to come together and put together the regulation, the rules. So, and this is going to be one that is going to require a joint working force between the Department of Homeland Security and Department of Justice. And that means bringing in sort of USCIS, ICE, CBP, EOR, sort of all of those components who have a say or some, sort of equity in this into that force. So I'll just leave it at that to say we've been tasked. We are committed to that task. However, it is a rule that has been in the making for 20 years. so it is a big challenge, and that's one that's we're up for it. We're going to do everything we can and to make sure that we meet the president's demands. But I think the context of it is important. But I'll defer to Professor Ramji Nogales as to what wishful thinking for PSG she has.
Yeah. So I mean, I think wishful thinking to the convention framework generally. This is actually a question I asked my refugee law and policy students, and if I had a magic wand and could change the definition, I think what I would do is I would eliminate the nexus requirement, so that it has to be on account of membership in one of those 5 grounds. So just anyone facing persecution that their government can't protect them from should be eligible for protection. And I think that would, a lot of the challenges we've been talking about, the non-state actor challenge, the gender challenge, I think that would make the convention really nimble and able to adapt, right? I think going back to the history, you have to remember the convention was initially designed as a temporary treaty. So it's actually extraordinary. I don't think, right, the drafters expected it would still be around in 70 years. So it's quite extraordinary that it's expanded so far. But I think that would be one way that you could really make the convention cover the various forms of harm that people are facing right now that the drafters understandably didn't envision. I think in terms of a particular social group, I think it's going to be a challenge. It's going to be contested. I would say it's going to be consistently contested going forward, as we've seen with gender. We've seen less actually with sexual orientation and gender identity. We've seen, right, those claims generally accepted in the U.S. So of course, one approach would be to amend the convention to explicitly include those, as Professor Goodwin-Gill suggested. I'm fairly sympathetic to that approach, though I've heard people who spend a lot of time thinking about these issues saying maybe it doesn't make sense to amend, and maybe we should just actually clarify what's within the scope of social group, because we don't want to end up narrowing or end up excluding any other groups. What I think in terms of what the Biden administration could do, I think probably the most helpful approach, I mean, obviously if some change can go through Congress, that would be wonderful, but I think regulations that identify various groups that are definitely within the social group category. I think that would be really helpful, really reiterating that persecution by non-state actors is covered under the convention. Again, again, there's a tension there, though, because I think it would be helpful to enumerate gender identity, sexual orientation, but then you worry that adjudicators feel less comfortable going beyond the enumerated grounds and adapting to new forms of persecution. So I think there are always challenges in generating new definitions, not least of which, of course, are the political challenges to any change to the statute or change to the convention. But certainly, I think and I hope the administration will work with the regulatory structure, because they are able to do that.
Yeah, and I think that ties into Volker's point a little bit about being careful as to what we throw out, because we don't quite know what we get moving forward, and certainly the political ramifications of refugee policy globally are significant. But that both of your remarks do lead me to one final question, perhaps, and one relevant to UNHCR, where I work, is UNHCR is the adjudicating authority, as you know, in about 60 countries globally. And one of the things I think we struggle with a little is how to maintain our own independence when we're adjudicating cases, and how to make sure we're setting up a system with access to lawyers and fair appeals and this sort of thing. And I wonder if either of you have reflections on the degree of independence we see with US adjudication, and whether that's something we might see reform in down the line.
Well, I think, as you know, this is me wearing my previous hat, I suppose. I think, trying to put it, the immigration court system was actually it was created as a result of a recognition of the conflict of interest that arose within the Department of Justice, that was responsible for both enforcing the immigration laws as well as adjudicating it. So the creation of Executive Office for Immigration Review, which now houses the immigration court, and the sort of administrative appellate body, the Board of Immigration Appeals, was born in 1983 specifically because of that, and throughout the years has grown greater and greater degree of independence, from sort of the goal being from sort of the pendulum swings of administrations and sort of political influences. The problem is that it is still ultimately within the Department of Justice, right? So what happens, as what we saw, for example, with previous administration, is that the court was more directly utilized as a direct sort of support for the goals. And I think that's something that is important for all of us to discuss, is to say, to what extent should these conversations, should these areas be subject to these sort of changing political winds, so to speak? Or is this something that is best to sort of allow for more independence through the very different parts? So you can have certainly the policy element. There are clearly sort of policy points that each administration should have the ability to focus on. But when it comes to sort of the long-term interpretations and some sort of degree of stability, should we be looking for something, a model that is more stable and more sort of insulated from the changing tides?
And my answer to that is yes, we should. In my scholarship, with my co-authors, I've repeatedly said, and I think there are a variety of ways we could make this happen, but I think given the political interference that we've seen with the Executive Office of Immigration Review, with the immigration courts and the Board of Immigration Appeals, the time is ripe now to think about a way to maybe move it into the judicial branch, or think about another way to separate the courts, to make them more independent, and to give the adjudicators the respect and independence that they deserve to make their decisions.
Well, I think this is a great moment to end with a voice as definitive as Professor Ramji Nogales on that point. Thank you all so much for your time. We're very grateful, and thank you for rolling with the technology challenges and the strangeness of working across the globe, particularly to Professor Goodwin-Gill for sending over a video. We'll work with ASIL now to have a final slide that has the links to Professor Goodwin-Gill's video, the Global Compact, and the executive orders, as well as anything else the panelists might have mentioned today. And we are very grateful to the audience watching this. And I'll close again with thanking the panelists and thanking ASIL. We are very glad to have been able to look at the convention both forward and backward today. Thank you.
Thank you.
Thank you.
Bye-bye.